Aboriginal title isn't directly spelled out in the Canadian Charter of Rights and Freedoms. That's more about civil liberties like free speech and equality. What you're probably thinking of is how courts have shaped it under Section 35 of the Constitution Act, 1982, which recognizes and affirms existing Aboriginal and treaty rights. It's a collective right Indigenous groups hold to their lands based on long-standing occupation before European contact, not just Crown grants. You can use it for traditional stuff like hunting or gathering, but not sell it off. That stays communal. Courts say it's inalienable, meaning it can't be taken without consent or fair compensation. Big cases like Delgamuukwa or Tsilhqot'in nailed down that proof comes from oral histories too, not just written docs. Got a specific part you want to dive into? Aboriginal title in Canadian law stems from Section 35 of the Constitution Act, 1982, which protects existing Indigenous and treaty rights. It's a collective, communal right to land, rooted in Indigenous groups' exclusive use and occupation before European contact, as affirmed in cases like Delgamuukwa and Tsilhqot'in. Unlike fee simple, you can't sell or split it. It's inalienable, staying with the community for things like hunting, fishing, or even commercial development, as long as it aligns with traditional uses. The Crown can only infringe on it for a compelling public purpose, like infrastructure, with consultation and often compensation. Proof leans on oral histories, not just documents, and it's stronger than mere usage rights. Anything specific you're curious about here? Yes, you're spot on. That statement about British Columbia, BC, being largely unceded territory, with the Douglas Treaties as a key exception, is a cornerstone of how Aboriginal title operates under Canadian law. It directly ties into the framework I outlined earlier, particularly through Section 35 of the Constitution Act 1982, which protects existing Aboriginal rights, including title. Let me break this down step by step, connecting the dots to unceded lands and those treaties. 1. What unceded territory means in Canadian law. Unceded refers to lands where Indigenous nations never formally surrendered or extinguished their rights through treaty, conquest, or other legal means. Unlike much of eastern and central Canada, covered by the numbered treaties or earlier agreements, about 95% of BC is unceded. This isn't just historical trivia, it's a legal reality that strengthens Aboriginal title claims. 2. Under Canadian law, Aboriginal title is presumed to exist where Indigenous groups can prove pre-sovereignty, pre-1846 for coastal BC, pre-1871 for the mainland, occupation that was continuous, exclusive, and not abandoned. The Crown, federal and provincial governments holds underlying title but must recognize and reconcile with Indigenous title, as affirmed in landmark Supreme Court cases like Calder v. British Columbia, 1973, which first acknowledged Aboriginal title in BC, and Tsilhqot'in Nation v. British Columbia, 2014, which granted a declaration of Aboriginal title over specific unceded lands in the interior. In practice, this means Indigenous nations in unceded areas retain collective rights to use the land for traditional purposes, e.g., hunting, fishing, cultural practices, and increasingly for economic development. The Crown can't just take or develop the land without deep consultation, justification, e.g., a compelling public interest like infrastructure, and often compensation or consent. 2. The role of the Douglas Treaties. These were 14 small-scale agreements signed between 1850 and 1854 by Governor James Douglas of the Hudson's Bay Company, later colonial governor, with specific First Nations on southern Vancouver Island, mainly Coast Salish groups like the Songhees, Esquimalt, and Saanich. What they covered: Douglas purchased about 0.3% of Vancouver Island's land, roughly 928 acres total, for small payments, e.g., blankets, cash, but the treaties explicitly reserved Indigenous rights to hunt, fish, and access the land as formally. They weren't blanket surrenders of entire territories. Instead, they were more like sharing arrangements from an Indigenous perspective, though colonial intent was to extinguish title for settlement. Legal status today: courts interpret these as recognizing ongoing Aboriginal interests rather than full cession. They don't erase title, but limit it in those specific areas. For the signatory nations, this means a mix of reserved rights and potential claims for fuller title recognition. Douglas stopped after 1854 due to funding shortages and the mainland gold rush, and his successor, Joseph Trutch, outright denied Aboriginal title existed, halting further treaties. This left the rest of BC, including the mainland and much of the interior, unaddressed. 3. How this applies to Aboriginal title province-wide. In unceded areas, most of BC, Aboriginal title is the default starting point. Nations like the Silhouette, who won title in 2014, or the Haida, with strong consultation rights over Haida Gwaii, can assert exclusive use and occupation rights. This has real-world impacts. Pipelines, mining, or logging projects often face legal challenges or require Indigenous consent under the duty to consult. Exceptions like Douglas treaties, these create a patchwork. The treaty lands are ceded in the sense of partial extinguishment, but Indigenous rights persist. Combined with Treaty 8, covering Northeast BC, signed 1899, they account for the small ceded portion. Modern reconciliation. Since the 1990s, BC has been negotiating modern treaties, e.g., NISGA in 1998, the first in over a century, to resolve outstanding claims. As of 2025, about a dozen are finalized, but many more are in progress. Unceded status amplifies leverage in these talks and courtrooms. In short, the unceded nature of most BC land bolsters Aboriginal title as a living, enforceable right. It's not just historical, but a tool for ongoing governance and self-determination. If you're thinking of a specific nation, case, or issue, like resource development, I can zoom in further. Overview of the situation in Richmond, BC. As of November 4th, 2025, the controversy in Richmond stems from a landmark BC Supreme Court ruling on August 8th, 2025, in Cowichan Tribes v. Canada, Attorney General. The court recognized Aboriginal title for the Cowichan Nation, including the Cowichan Tribes and allied First Nations, over approximately 5.7 square kilometers, about 1846 acres, or 750 acres in some reports, of land along the Fraser River on Lulu Island in Richmond. This area, known historically as the traditional summer village, site of Tilicanis, was used for fishing and resource harvesting by Cowichan ancestors for generations until colonial appropriations in the late 1800s. The lands now include a mix of federal crown holdings, e.g. Port Authority, provincial and municipal properties, and around 150 private fee simple properties, homes and businesses that owners believed were securely theirs. The ruling declared Crown and City of Richmond titles over these lands defective and invalid due to unjustified infringements on Aboriginal title, but this invalidity is suspended for 18 months until roughly February 2027 to allow time for negotiations and an orderly transition. Importantly, the Cowichan Nation did not challenge private property titles directly in the case and has publicly stated they have no intention of erasing or seizing private homes. However, the decision has sparked widespread anxiety among homeowners, with the City of Richmond sending warning letters about potential ownership risks, packed public meetings, and even halted financing for development projects due to uncertainty. Governments are appealing, and Premier David Eby has called for calm, emphasizing that fee simple ownership remains the foundation of BC's property system. What will happen to non-Aboriginal homeowners? For the roughly 150 affected private homeowners and businesses in Richmond who aren't part of the Cowichan Nation, the immediate outlook is one of uncertainty, but not catastrophe. No one is facing eviction tomorrow. Here's a breakdown based on the ruling and ongoing developments. Short term, next few months. The 18-month suspension provides breathing room. Homeowners can continue living in and using their properties as usual. No changes to titles or occupancy are enforced yet. The provincial and federal governments, along with the City of Richmond, are seeking a stay of the decision's implementation while they appeal to the BC Court of Appeal and potentially the Supreme Court of Canada. This could pause any disruptions for years. Public backlash has led to actions like mass property tax appeals from affected owners, arguing the ruling has devalued their land, potentially slashing market values by creating clouded titles. Richmond's mayor and council are advocating for exemptions for private homes. medium-term outcomes after suspension. Coexistence and negotiation. The court emphasized Aboriginal title and private fee simple interests can coexist, as seen in a recent Haida Nation ruling over Haida Gwaii. The Crown, governments, has a constitutional duty to facilitate good faith talks between the Cowichan Nation, homeowners, and municipalities. This could result in reconciliation agreements, such as shared governance, easements for cultural access, or revenue sharing from developments without displacing residents. Potential impacts on sales or financing. If you try to sell or refinance, lenders might hesitate due to the title uncertainty. Lawyers note private titles aren't automatically invalid, but they could be challenged if sold without consent in the future. The Cowichan have suggested private properties would only be addressed upon sale, potentially through buyout offers. Compensation or buyouts. If overlaps can't be reconciled, the Crown might step in with fair compensation, e.g., market value buyouts, funded by government, honoring the honor of the Crown principle. Homeowners aren't expected to bear the full cost of historical infringements. Worst case scenario, unlikely. If appeals fail and negotiations break down, courts could order adjustments, but experts stress this wouldn't mean mass evictions. Reconciliation prioritizes minimal disruption in urban areas. In essence, affected homeowners are in a limbo phase, but the system is designed for resolution through dialogue, not demolition. Groups like the Richmond Property Owners Association are forming to push for protections, and surveys show strong public support. 75% of BC residents view this as a serious issue. What will happen in general? This ruling is a seismic shift for Aboriginal title in BC's unceded territories, which cover 95% of the province, but it's more about accelerating reconciliation than upending society. Broader implications include legal precedent. It opens the door for more urban land title claims, as it proves title can be established in developed areas with strong historical evidence, like oral histories and archaeology. Similar cases are already emerging, e.g., an Algonquin claim in Quebec. However, it reinforces that infringements must be justified, e.g., for public good, with consultation and compensation, echoing Silhacoten, 2014. The government and reconciliation push expect a surge in modern treaty negotiations and interim agreements. BC has finalized a dozen modern treaties since the 1990s. This could speed up more, especially in the Lower Mainland. The NDP government faces political heat. Opposition calls it a floodgate for claims, but EB insists it'll clarify that private titles take precedence. Federally, it's tied to broader UNIP implementation. Economic and social ripple effects. Resource projects, e.g. ports, pipelines, in disputed areas will need deeper Indigenous consent, potentially delaying developments but fostering joint ventures. Public anxiety is high. 60% of British Columbians polled say it harms reconciliation, but it could ultimately lead to equitable wealth sharing from lands long under Indigenous stewardship. Timeline. Appeals could take 1 to 3 years, with a possible Supreme Court of Canada referral. By then, negotiated deals might resolve much of the Richmond issue. This is a pivotal moment for Canada's commitment to Indigenous rights, but it's rooted in healing historical wrongs, not punishing current owners. If you're a Richmond resident or have a specific property in mind, I recommend checking with the city's resources or a local lawyer for personalized advice. What's your angle on this? Personal concern or just following the news? Selling a home in the affected Richmond area. Key Selling a home in the affected Richmond area. Key implications. No, you do not have to pay the Cowichan tribes or any Indigenous nation directly when selling your home under the current Cowichan Tribes v. Canada ruling. The decision doesn't impose royalties, fees, or mandatory payments to the nation as part of a private sale. Instead, it creates a layer of legal uncertainty around the underlying title, which could complicate the transaction without triggering any automatic payout. Let me break this down based on the August 2025 BC Supreme Court ruling and its fallout as of November 4, 2025. 1. The legal setup. No direct payment to the tribe. The court recognized Aboriginal title for the Cowichan Nation over about 732 acres out of their claimed 1,846 acres in the Tuluktanis area on Lulu Island, including some private fee simple properties, your standard homeownership. However, the Cowichan did not challenge or seek to invalidate private titles in the case. They focused on Crown, government lands. The ruling declared Crown-granted titles, federal, provincial, and City of Richmond. Selling a home in the affected Richmond area. Any nation directly when selling your home under the current Cowichan Tribes v. Canada ruling. The decision doesn't impose royalties, fees, or mandatory payments to the nation as part of a private sale. Instead, it creates a layer of legal uncertainty around the underlying title, which could complicate the transaction without triggering any automatic payout. Let me break this down based on the August 2025 BC Supreme Court ruling and its fallout as of November 4, 2025. 1. The legal setup. No direct payment to the tribe. The court recognized Aboriginal title for the Cowichan Nation over about 732 acres out of their claimed 1,846 acres in the Tuluktanis area on Lulu Island, including some private fee simple properties, your standard homeownership. However, the Cowichan did not challenge or seek to invalidate private titles in the case. They focused on Crown, government lands. The ruling declared Crown-granted titles, federal, provincial, and City of Richmond holdings defective and invalid due to historical infringements, but it explicitly noted that private owners weren't parties to the litigation. This means your fee simple title isn't automatically voided or subject to a tribute to the nation. Reconciliation for private lands falls to the Crown, governments, not individual sellers. The court directed good faith negotiations between the Cowichan, governments, and affected parties to resolve overlaps, potentially through coexistence models like those in the recent Haida Gwaii ruling, where Aboriginal and private titles share space without one erasing the other. No mechanism exists, yet, for the nation to extract payments from sales. That's not how Aboriginal title works under Canadian law. 2. Practical impacts on selling your home. Title uncertainty and market effects. The big hurdle is the cloud on the title. Buyers, lenders, and title insurers now know about the claim, which could scare them off. As Richmond Mayor Malcolm Brody noted in letters to 150 affected owners, this may compromise the status and validity of your ownership, making sales tougher. Reports show home values in the area have dipped. Example, some multi-million-dollar properties down 10 to 20% due to buyer hesitation. Financing is stalled. Banks have pulled loans for developments, and real estate lawyers advise disclosing the ruling in sales contracts, which could lead to lower offers or deals falling through. If you sell now, during the 18-month suspension until February 2027, expect longer timelines, price negotiations, or even no-shows from cautious buyers. When might a sale trigger something? Lawyers for the Cowichan have suggested private properties might only be addressed upon sale, potentially via government-facilitated buyouts or agreements. But this isn't a pay-the-tribe scenario. Any resolution would involve the province, federal government compensating you. Example, at market value, if title adjustments are needed post-appeals. No fixed how much exists. It would be negotiated case by case, likely through fair market appraisals, plus any devaluation from the uncertainty. Taxes and fees. Standard real estate taxes, commissions, and legal fees apply as usual. No Aboriginal-specific levy is mandated. 3. How much could this cost you indirectly? 0 direct to the tribe. As emphasized, nothing flows to the Cowichan from your sale proceeds. Potential indirect hits. Lower sale price. If the cloud persists, you might net 5 to 15% less than comparable homes outside the area, based on early 2025 reports from affected Richmond sales. Legal, insurance costs. Title insurance might cost extra, $500 to $2,000, or be unavailable. A real estate lawyer, $1,500 to $3,000, is essential to navigate disclosures. Buyout scenario. Post-resolution. If negotiations lead to the nation acquiring the land, unlikely for homes, more for commercial, governments could offer full market value plus relocation aid, potentially more than you'd get in a depressed market. But this is speculative and years away. In short, the cost is mostly opportunity, delayed sale, reduced value, not a payout. Premier David Eby has stressed protecting fee simple rights as key to economic certainty, signaling government intervention to minimize hits. 4. What's next and how to protect yourself? Appeals in play. The City of Richmond, province, feds, and even the Musqueam Nation are appealing, with the Cowichan cross-appealing for more land. A stay could freeze changes for 1 to 3 years, buying time for sales. The BC Court of Appeal might clarify private title protection soon. Government role. Expect more talks. Eby tried, but failed to involve owners early. The First Nations Leadership Council insists coexistence is possible and not a threat. Advice if selling. Get a title search and lawyer ASAP. Disclose the ruling transparently to avoid lawsuits. Attend Richmond's follow-up sessions. Next one likely soon, after the October 28th meeting, or contact City Hall for updates. Consider waiting. Many experts say hold off until appeals resolve for clearer titles. If you're in a pinch, explore seller financing or cash buyers less phased by risks. This is uncharted territory, but the system prioritizes reconciliation over upheaval. No mass pay up or lose your home vibes. It's more about shared stewardship than extraction. If this is your situation, what's the timeline for your potential sale? I can help brainstorm next steps.